Thank you all for being here today for our quarterly meeting that was rescheduled. We decided to reschedule it from May until now because we figured we would know more now, which we do. We don't know everything yet because the governor's not done with his work. But we know enough to at least give you all an update. So we're going to start off first. Jennifer's going to give you an update on our budget, how OCA's budget went. And you all will recall back last summer, we, in one of our quarterly meetings, talked about all the things that we were asking for. So now you're going to get a full picture of what we actually got or didn't get. That is all subject to change if the governor decides to veto some things or allow them to veto some things. So until July the 18th, we don't really know for sure, but presumably we'll presume this is the way it's going to be and then be shocked if there's something that's vetoed. Maybe we shouldn't be shocked. But the other thing is that at the end of this, I'll also give you an update on some of the bills that affect OCA and then an update on some of the Judicial Council bills and what the status of those are. So without further ado, I'm going to turn it over to Jennifer. She's got a lot of information here for you to take a look at.
Thank you. I'm going to stand over here so I can see it. So since it's been about 10 months since we went over our budget request, I thought I'd go through, like David said, go through the total request and the exceptional items that we asked for, and then talk about the recommendations that the LBV made during session, as well as adjustments by the conference committee, and then just show you some summaries, and then we'll open it up to questions. I'm going to go fast because I saw the list of bills that David wants to go through, so I'm going to try to make this quick. We asked for $153 million for the biennium. If you break it out between OCA and TIDC on the left, it's $87 million is tied to OCA, $66 is tied to TIDC. Those of us in the budgeting world really like to keep an eye on how much we spend in direct costs, which are costs associated with one cost objective like JVCC or TIDC. And then we look at indirect, which affects multiple cost objectives like HR, finance and operations, IT, those kinds of things. So we look really great when you look at our percentage of support versus what our direct programs are. Down in the bottom, our method of finance, you can see Fair Defense is our largest funding source, followed by e-filing, and then GR, we've got $42 million, and then we have about $15.5 million for the interagency contracts, which is the children's courts reimbursement from the Office of Attorney General. The chart shows you how our budget is broken out by strategy. Largest, of course, is TIDC at $66 million. Then we've got IT, which includes e-filing, vendor payments. And our children's courts make up about 16% of our budget, and court admin is 5%. And then JVCC, is about 1%.
Jennifer, that's a good quick question.
Yeah, sure.
So the 10% for the child support courts, that $15 million, is that the GR and federal portion?
No.
Is that
Well,
just
no, it is.
It's
That's
both. It's
both.
combined.
It's both, because it's looking at it by strategy. So if you're curious of what we spend our money on, the majority, of course, is the grants for the TIDC program. Other operating expense includes the massive e-filing payments, so that's pretty large. Salaries makes up 23% of our budget. We spend over $1 million in travel, which is huge from where I've come from. That's a lot of money in travel, but based on what we do, it makes sense. So this is my favorite little chart that I showed you last time. When we met and talked about the budget at the beginning in August, we were at the top part of the schedule, but now we're down here. We're still waiting for the governor to sign the budget bill, so David said there could be some changes, we hope not. So we submitted a request of 96% of our 16-17 levels, which cut our budget by $6 million. You may recall there was a directive that all agencies cut by 4%. So that was $6 million for us. We submitted 7 exceptional items totaling $238 million, and we asked for an additional 60 FTEs. Wow. Yeah. Our first item, we made it.
I don't think we can fit them in.
No. Unless. So we made it a priority to try to find funding for staff salaries. So that was our first priority. Our second was to ask for a position to create a court security and emergency preparedness division. So that was about $93,000 a year and 1 FTE, which resulted in Senate Bill 42, which I'm sure David will talk about. Our second item, due to the success of the guardianship compliance program, the pilot project, we asked for funding to create a full-blown program that would address compliance across the state. It would be 39 FTEs. with 28 guardianship compliance specialists, 2 managers, 4 licensing and criminal history experts, 2 quality review training positions, and then 3 additional admin staff to handle all this extra load in travel and operating. We asked for 4 new child protection courts, and we asked to add IT support staff to provide regional technology support for all courts outside of Austin. TIDC asked to restore the 4% reduction of $2.9 million. Our 5th item, TIDC asked for funding for the Regional Public Defender Office for capital cases in Lubbock County. They're currently funded at 24% of the program cost, and they sought to bring that up to at least 50%. TIDC also asked for funding for early identification and representation of defendants with mental illness. It's been reported that $650 million in jail costs each year are due to inadequately treated mental illness and substance abuse disorders. And you've got a pool of about 14,000 people that seem to keep going through the system because of this. So this money would provide programs to give assistance and connect defendants with support. And he asked for an additional 1 FTE for that. Lastly, TIDC asked for additional funding for indigent defense. The state is only covering 12% of those costs. The county's having to bear the difference. So this exceptional item was seeking to at least bring it a 50-50 split with an ultimate goal of 100% during the 22-23 biennium and 4 FTEs. So when agencies submit their operating budget, their LARs to the LBB and governor's office, they scour them, they analyze everything, and they almost always come up with additional cuts that you don't want them to take because they're trying to show that they're going to save the state money. So we had some things in our baseline that we hoped they wouldn't notice, but they did. So they took out the funding for the Exoneration Commission with 2 FTEs. We tried to retain some of our CAPS funding because the Courts of Appeals are currently going through user acceptance training for CAPS financials. And just with the experience that my staff has had to go through and the heartaches and the headaches of that system, we know that they're going to need support, and they go live on 9/1. So we were trying to keep some of that money, and they said, nah, you can't keep it. They eliminated the funding for the pilot project for the guardianship, which was 3 FTEs and $590,000 for the biennium. So that's about $1.2 million in addition to the 6 they took from us. A little painful. The final thing they did, which is unfortunate, is we have 2 funding sources, e-filing and the Fair Defense account that had estimated authority for the appropriation. So why that's beneficial is because these GR dedicated accounts are only for those specific purposes. And there's a number in the bill pattern of an amount. Well, without that estimated appropriation authority, we're limited to that amount in the bill. If we collected revenues above and beyond that, we can't touch them. So this was a painful discovery when we got our recommendations. It wasn't OCA directed, it was statewide. So anybody that had this in their bills, it was eliminated. It was in an effort to contain costs for the certification of the bill. So which exceptional items survived? Exceptional item number 1, unfortunately, we didn't get that funding. Sadly. We did get the funding for the Court Security Emergency Preparedness Director at about $93,000 a year, and that was Senate Bill 42 driven.
Can I ask a question?
Sure.
Who's going to support that person?
We are.
It's going to be through Research and Court Services.
The Guardianship Compliance Program, we got it, which is great. They gave us funding at 80%. So out of the 39 FTEs, we're getting 31 and $5.2 million. This is really a great thing, and we're going to start getting the wheels turning on getting the staff, and you're probably wondering where the heck are we going to put all these people. The majority of them will be regional, but we will have to find some space for some people to bring them on. Children's courts and IT support staff, unfortunately, they did not survive, nor did TIDC's 4% funding restoration. The RPDO funding did not survive either.
I like the way you did this.
And the ID and representation.
I don't like it.
That also did not survive. And as well as the $212 million in GR request did not make it. Yes. Okay, so the House and the Senate each submit their version of the budget bill for consideration. Of course, they're going to have differences. So when they have differences, they create a conference committee. It's made up of 5 members of the House and 5 members of the Senate. So they can make it, in addition to approving the exceptional items, they also can add things or take things away. So there's 4 more changes that occurred for us. 2 of them we asked for, 2 of them we didn't. The capital authority for our IT projects, we asked for those, so they gave those to us. The other oddity is transfer the Forensic Science Commission from Sam Houston State to OCA, and then the contract cost containment rider reduction. I'll talk a little bit about those. So the e-citation grant, you may remember last year, Sam and Tom did a great presentation on the e-citation program or the project. So we're anticipating getting funding for phase 2, which is about $2.7 million. But whenever you have a capital project that exceeds $100,000 for the biennium, you must have capital authority in your capital rider. Well, at the time we did the LAR, we didn't know if we were going to get this. So we had to ask for that so that we would be able to actually do the project. The same with the fines and fees project, affectionately known as Flamingo. We got some Department of Justice funding to create a tool, an ability to pay tool for use by the courts, and to provide alternatives for community service. So we needed authority for that as well. So it was good that we got that, because we'd have to kind of stop. Yes?
What's capital authority? If it's too long, you can tell me later.
No, in the bill, capital is if you're buying trucks, or if you're doing an IT project, programming, buying an asset. If it's over $100,000, you have to have explicit authority in your bill pattern to buy it.
Okay, thank you.
And IT is the same way, because it's a major information resource project, so they require that. The Forensic Science Commission, Senator Hinojosa authored Senate Bill 1124 to transfer the Forensic Science Commission from Sam Houston State to OCA. It was created in 2008. They determined the second most common contributing factor to wrongful convictions is negligence in forensic science analysis. So this commission has 9 members, 7 scientists, 1 prosecutor, and 1 defense attorney, and they investigate negligence or misconduct that would substantially affect the integrity of the lab results. They also oversee the Texas Crime Lab Accreditation Program. So they will now be administratively attached to OCA, so we'll be doing their payroll, doing their reporting, pay their bills, all that kind of good stuff, and provide IT support. Also, the analysts are required to be licensed by January 1, 2019 and pay a fee. So Senator Hinojosa also passed Senate Bill 298, which creates a new general revenue dedicated account. So all those revenues will go into that account to be spent by the commission.
So that's a new regulatory?
Yes.
Pseudo-regulatory.
And so they are located in the Stephen F. Austin building on the 4th floor, and they'll stay there. They're not coming out.
They're next door to OCFW.
Yes, exactly.
So just a reminder from earlier, they have 3 staff, and those 3 staff will now be OCA employees, basically, so we'll have 3 additional staff.
Will they come to our meetings?
They will be, we should have invited them to this meeting.
Oh, we should have.
I was thinking about that. They're not technically
Well, it's
OCA
not
staff
technically
yet,
until
but,
September 1.
so those 3 staff will be the ones who will be responsible for continuing to support the Forensic Science Commission.
So are they gonna be like spa? It's kind of
Yes.
Okay.
Mhm. Yeah, exactly, and like TIDC. Okay, ever since the CT21 fiasco from 3 years ago at HHSC, the legislature has really had their microscope on contracting. So in an effort to force agencies to find savings in contracted goods and services, they put this rider in the bill. They looked at all agency spend patterns on contracting over a 3-year period and came up with a percentage and a grand total number they wanted to hit, which is $500 million. So they imposed these reductions. That's that 69,000 that was on that orange chart that they're taking from all agencies. Some of them hit a lot harder, like HHSC got hit really hard. So we didn't get hit too hardly. But we're still going to have to report how we saved money, and it gives you strategies for best practices in contracting, whether you cancel the contract or renegotiate. So that was a surprise that came in this session. So in summary, looking at OCA alone, our budget increased 7.33%. GR, of course, because of forensic science and the guardianship program. E-filing went down a little bit because of the 4% reduction. Interagency contracts went up hugely because of the TxDOT grant, because that's the funding mechanism for it. So we looked $6.5 million more than we had before. On the other hand, TIDC didn't fare as well. They lost $4.7 million due to the 4% reduction and reduction in court costs coming in. However, there's a bright side for them. Senate Bill 2053 was a consolidated court cost bill, so part of the Fair Defense account revenues come from consolidated court costs. So there's like 9 other funding sources that get money from those. A couple months ago, Court of Criminal Appeals determined that 2 of those revenue allocations were unconstitutional because they weren't spending their money on a criminal justice purpose. So Senate Bill 253 redirects those revenues into the Fair Defense account, which is great. We're waiting for governor approval on that one. Bad thing is the contingency rider that actually appropriates the money on the other end, you have to have those 2 pieces, the statute and the appropriation authority. That rider didn't get put in the bill. It was intentional. They didn't do it. They gave us the money, but not the appropriation
Why would
authority.
why would they do that, Jennifer?
Because they're trying to contain and use it for certification of the bill.
Certify my budget.
So they get to keep that money to certify the bills, and it's not set aside for another agency use. However, had we retained our estimated appropriation authority, we would have had access to that money. So next biennium, we're going to fight to get authority for this to help TIDC out, and that'll give them an extra $32 million a year, a biennium. So that's a good windfall for them. They just have to watch it grow. And then they'll get it hopefully next biennium. Okay, one more thing. For those of you that travel, you may recall that there's a maximum allowance for cities and counties that don't have a specific federal program in the GSA, and it's no more than $85. Well, the GSA increased the rate to $91, so it's been causing a lot of confusion with agencies on how do I pay them their $91, so you have to adjust their meal allowance. It's just been a headache. So they're eliminating that language. So that's going to be gone September 1. So if this GSA ever changes, this is the line that shows what the rate is. If it goes up to 100, you don't have to worry, you get your $100. You're not stuck with 85 anymore. If you're curious how we fit in the, yes, this is the entire state budget, $216
We're
billion.
better than we used to be.
Here we are. Down there in the middle. Yeah, we're the little planet in the middle. So 0.4% of the overall state budget is the judicial branch.
That's actually rounded up. Actually, it may ask, it's 0.38%
Yes,
of the
yes.
entire budget.
Yes. Okay, so now this is David's turn to go over all these.
See if anybody has any questions.
Don't you have any questions on any of that?
We'll send out the presentation when we send out the link too.
Very good.
Thanks, Jennifer. That was
Thank you,
very
Jennifer.
helpful. You did that really fast. I think we're going to get out.
Oh, okay.
People
Might be
So,
hungry.
the bottom line is that, our top priority was, as we talked about earlier, was getting some funding for staff salary increases. Unfortunately, we were not able to secure that funding. We're looking at the budget to see what we can do or can't do, but just stay tuned on that one. But unfortunately, in a top budget situation, staff salary increases are not always their top priority, unfortunately. We did make a lot of progress, I think, with them understanding the need, why we needed it and why we were different than maybe every other agency asking for staff salary increases, but that's just the way it went. CIDC, as you saw, got hit particularly hard. We didn't get any of the child protection court stuff that we wanted or the support for the child support courts. So we've got some work to do for next session to think about, but I think overall, most of us think it was a pretty good session from a budget perspective for OCA and the judiciary overall. So let's talk a little about some of the bills that, these on this page are bills that directly affect OCA. So these are the number of bills that were passed that have a direct implication on some work that we have to do, either starting either over the entire biennium and ongoing, or just a special project. So I wanted to kind of talk to you about each of those as today. So first of all, House Bill 29 is a bill that is a long bill, does a lot of issues, but it deals with human trafficking. And for a number of years, the Attorney General's office has had a human trafficking task force. OCA has never been a part of that. Really, the judiciary has never been a part of it, but obviously human trafficking has a direct implication many times with the court system. And we've been doing some work on human trafficking in other areas. This bill, we didn't ask for this, but I suppose they thought the judiciary was an important one as well. And we were glad to see that it adds OCA as a member of the Human Trafficking Prevention Task Force. So we'll now have someone who will be functioning on that task force and working to try to help prevent human trafficking. If you don't know much about human trafficking, maybe we need to do a session about that at some point, because it's a pretty horrific, the term that's being used is modern day slavery, either sex slaves or work enslaved for work. So it's pretty awful situation, but it's more common than you might think. The second bill, HB 1507, deals with new forms. This is a bill that we worked with the dean of the UT Law School, Royal Ferguson, in the representative's office. I know Margie worked on this. I saw Margie a second ago. Where are you at, Margie? There she is over there. Margie was working on this issue, but basically this is a bill that deals with creating forms so that when people complete their term of service on probation, that they can have their rights restored. And this is a way to make sure that can happen. It's already allowed under law, but there's not a good way to make it happen. And so this requires OCA to actually create forms that would simplify that process for people to get some of their rights restored to them. So we'll be working on that over the next several months. House Bill 3167 actually raises the population bracket for mandatory collection improvement programs. Right now, the population bracket is for counties 50,000 or above. They have to have a mandatory collection improvement program. This raises that to 100,000 or above. And so what that did by that one little change is it knocked out 23 counties or 23 programs that were responsible for or required to have a mandatory collection improvement program. So certainly changes the work of our collection staff, and that's something that the legislature passed on.
That brings less revenue for the state.
Perhaps. It depends on how the counties choose to do their collection improvement programs. If they just cease doing any collection activity, then obviously it could have a less revenue. But I believe the fiscal note from LEB was no significant fiscal impact was impacted by it.
The language didn't say that they had to stop operating.
No,
It
of course
says
not.
It's just not required.
They're no longer under the requirements from the collection improvement program rules, which Judicial Council adopts, or the audits. So it affects both our.
So I'd imagine if it's there today, it'll still be there. It's just not required to be there.
So we're looking at the implications of that as well. And then the rest of these are Senate bills. I didn't really realize that until just now, but it looks like the Senate did a lot more. There are a lot of Zaffarini bills here, that's for sure. So Senate Bill 36 is a Judicial Council recommendation, and it deals with the regulation of guardianship programs. Right now, JBCC, and for some time, has been responsible for regulating guardianship professionals, private professional guardians and others, and also putting into place minimum standards or standards of conduct for guardianship programs, but had no authority to actually enforce those standards that they were required to implement. And so what this does is it puts in place the requirement that JBCC also regulate the programs. So JBCC will be getting additional, how many programs do we think there are?
It's less than 30.
Yeah, like 30 different additional programs. So it's not a tremendous amount of increase in workload, but a lot of these programs are one-person programs. People trying to get around the regulation with a different backdoor way of doing it. So anyway, just that's one thing we'll be dealing with. Senate Bill 42, Jennifer's mentioned it a few times. This was the big court security bill that Judicial Council worked on. It's actually was titled the Judge Julie Kasurik Court Security and Courthouse Security and Judicial Security Act. It was obviously in response to it started in response to the attempted assassination of Judge Kasurik here in Austin back in the fall of 2015. We did a lot of work and made a lot of recommendations with regard to improving court security, and this is the bill that passed. Basically, it does a couple of things. One, it requires counties and cities to have a court security committee at the local level, and it tells who are on that committee, and the basic goal is for them to be discussing how to best implement security practices in their local jurisdiction. Also requires some changing in the reporting to OCA. As you know, right now, the local administrative judge is required to report court security incidents to OCA. This changes that to whoever's in charge of court security. A lot of times local administrative judges were saying, we don't know, no one ever tells us. So the people who are actually doing it will be required to report that to OCA. It also requires, this is a big one, requires personnel who are responsible for providing court security to be trained and certified. So there's a state certification that will occur with regard to court security officers, so that's a big improvement over what we have today. You might be surprised to know that many people who are providing court security now don't have any training in providing court security. So this is an attempt to try to remedy that. The big pieces for OCA are, one, it requires OCA to have a court security division. So basically there will be, we're not going to create a whole separate division, but it'll be under Research and Court Services. And right now the division is one person, the Court Security Director, which is what was funded through this bill. That person's responsibility will be providing technical assistance and consulting services to counties and cities across the state, to judges directly, to try to improve court security. So we're really excited about that. And then lastly, we're required to also work in determining and promulgating and putting out best practices for judicial security. So that's something that you'll see a lot of work on from us. Senate Bill 43 was a really long bill, which we're calling the JVCC cleanup bill. You might recall, if you were here a couple years ago in the 2013 session, we consolidated 4 separate boards into the Judicial Branch Certification Commission. There was a really long bill at that time that was passed that basically created JVCC. And so from 13 until now, we've seen the things in there that we would like to have changed. And so this was what the bill did, to try to change some things. So it's kind of minor tweaks to the system, but are really meaningful from an administrative standpoint. So just to give you 2 examples. One, right now, people's licenses expire at the end, like for instance, court reporters expire at the end of December, all of them. So you can imagine the work on our staff in October, November, December of each year where they have licenses expiring. They will now expire on the month of their birthday. So now we'll have expirations staggered out throughout the year. And then the other thing too is right now we have 4 professions that are regulated. One of them is a 1-year license, one of them is a 2-year license, and a couple of them are a 3-year license. So it's just, kind of keep that straight. It's a bit of a mess. So these will all now be 2-year licenses. So those are some of the things that were changed, which are not insignificant, but certainly very meaningful to us at the staff who work with JVCC. Senate Bill 47 is a new study that we're required to do. OCA is required by this law to study fine-only misdemeanor record availability. So basically, Class C misdemeanors, fine-only cases that are handled by our JP municipal courts. Some of them make those records of those convictions widely available. They may sell them, they may report them to DPS, and some of them don't make them available at all. So the question is, how is that happening all across the state? Obviously, the goal here, stated goal of the authors of this bill, were to try to reduce the impact of convictions for fine-only misdemeanors on people's ability to get employment or to get housing. And so they want us to do a study on how is that working across the state with regard to their availability. And stay tuned on that one. We're not exactly sure who will be doing that, how it will be done. It is a very big undertaking because it requires us to collect that for every jurisdiction, which there are a lot of. There were 2,000 JP municipal court judges. So anyway, we'll see how we're going to do that one, but that's definitely a study that'll take some work. Yeah, and no money was provided. Senate Bill 73 requires all agencies in the state to have a leave policy that addresses certain things. We believe our leave policy addresses most of the things that are required, but we may have to do some updating with regard. This is in response to, you might have read in the Tribune several months ago, or any of the newspapers about agencies who were giving emergency leave for certain purposes which maybe were not legitimate or not, at least not what was intended by the legislature. And so this is a response to that. So there are only certain things you can use leave for. It's really no change for what we were using. For instance, emergency leave we weren't using for the purposes that came under scrutiny. So anyway, you'll be seeing that updated.
Post it on your website too if you give so much.
Right, that is true. This bill does require if we give over 32 hours of emergency leave, we have to post the employee's name and the leave on the website. So don't ask for more than 32 hours. So it's just a way to try to discourage agencies from giving emergency leave for purposes which are, I think we had like less than 5 people who got over 32 hours. We had to give a report to the LDB on this issue. But anyway, stay tuned for that. Senate Bill 291 is a new reporting requirement, so our judicial information team gets something new to work on because they don't have enough already. Basically, you might recall in Harris County last year there was you may not know this, there was a a victim of a rape who was homeless, and because they wanted to make sure she showed up to testify, they actually jailed her under a writ of attachment, which they can do. And so it became a huge issue in the media, of course, and it actually, perhaps the DA who was responsible for the office that sought that writ of attachment actually lost the race. A lot of people think that this may have been sort of the turning point because of these actions. So this bill limits what they can do with writs of attachments. Before, you could actually get a writ of attachment without a judge ordering it. You could go to the clerk and get it. This now requires there be an actual order from a judge. It also requires any time that one is sought that they have to report to OCA. So we're going to know about every single one of these. My guess is after all the attention with this, there probably won't be very many reports coming in, but we'll need to figure out exactly how we're going to implement that as well. So that's a new thing.
Just to clarify,
Yes.
you said that that law enforcement presumably could seek one from a clerk?
I believe so.
In jail?
Actually, a writ, yeah. So if you look at the way they changed it, they basically make it where you can't get it from a clerk. You have to get judicial order to do that. But to jail someone without a judicial order is quite extreme. So interesting way of doing this. So that's a new reporting requirement. We have another one you'll see somewhere. I'll see down there. Senate Bill 667 is, we were glad that they didn't choose the number before that. There's actually a joke behind that because Senator Zaffarini went in to file this guardianship compliance program expansion, and the bill up was 666, and she said she would not file the bill. So they waited until Senator Kolkhorst brought in a bill that requires restaurants and others to post signs post signs in the restrooms regarding human trafficking. I said, well, that's probably more appropriate.
Did it pass 666?
I don't remember if 666 passed or not. I think it did, but I haven't looked again. But 667 is the expansion of our guardianship compliance project statewide. Jennifer talked about it in the budget section. This is huge. This will be you all have heard Jeff's presentation on the guardianship compliance project and the huge success. Just got an email from Jeff this morning. We've got counties across the state beating his door down to get our staff there. Our three staff who actually I don't think they're here today. 3.5 staff. That's right. Our 3 staff have done a remarkable job on this project, so much so that it's obviously been very well received. Interestingly enough, on Senate Bill 667, there are 9 members of the State Affairs Committee that have oversight over OCA in the Senate, and they're the ones who heard in the interim about the guardianship compliance project. When this bill was filed, it was filed with 10 co-authors, all 9 members of the State Affairs Committee, and then Senator Perry, whose Lubbock situation was reported about in the Texas Observer, I think we told you all about. So 10 co-authors out of 31 members of the Senate. This flew through with literally no changes from the time it was filed to the time it passed. So the governor has not signed that yet, so we'll see, but presumably that project should be in place. We could have done the program with just the budget and not the bill, but now this makes this a core mission of OCA because it's in statute, so it sort of helps us from a budget perspective going forward. So Senate Bill 1096 is also related to guardianship. This is huge as well. This was, I should say, 667 was a Judicial Council recommendation, obviously. 1096 was also a Judicial Council recommendation. And basically what it does is it says that right now, under current law, if you are a family member or a friend or an attorney, you do not have to get any training. You don't have to be registered with the state. There's no authority to oversee you. But in fact, about 96% or 98% of all the issues that we found in the Guardianship Compliance Project dealt with family members and friends. Many times it's not because they are choosing to steal from mom or dad or grandma or aunt or uncle, but it's because they don't know what they're doing. They don't know their obligation with the law. They've not been properly trained. So what 1096 does, a couple of things. One is it requires all family members and friends to register with state. So before they can be appointed guardian, they have to register. So they'll be registering with JBCC. We usually see some of the funding for the staff comes through that. They'll also have to receive training before they can be appointed. So we're working on an online training module right now that they can access. We will also be responsible for doing the criminal background checks that have been required for a couple of years under the law, but every clerk was doing it differently, how they wanted to do it. And so basically, under this bill, that responsibility is when they register with the state, we'll do the criminal background check and then let the judge know that, yeah, they pass, or I guess we don't pass them, but we tell them what the criminal history report shows. So the other thing that's really important about this bill is we're also responsible for providing a mechanism for sharing this information with law enforcement through the TLET system, so IT component here as well, where basically if you're a law enforcement officer and you run into someone on the street, you can check to see if they're under guardianship, because a lot of times these people under guardianship get taken to jail, and that's not where they need to be if they're just out wandering around or whatever in law enforcement. So law enforcement will know who their guardian is, be able to contact them and get them back wherever they're supposed to be. So big improvement there. And the registry is actually, we were already anticipating this, and it's already being built into the new Reversa, whatever the real name's going to be, but that's the new Versa. So anyway, that's a new project that's pretty significant as well. Jennifer talked about the Forensic Science Commission. That basically transfers to OCA sometime between September 1st and December 1st. We have all their money now, so I'm assuming they're going to want to be here September 1st. But we have to do an MOU with them, with Sam Houston State. Sort of the backstory with that is the Forensic Science Commission got started and got attached sort of Sam Houston, and then when the Senate filed its introduced version of the budget, it zeroed out funding for the Forensic Science Commission, just like it did for a number of other sort of special programs at universities. And so I think this was his way of trying to make sure there was some stability for the Forensic Science Commission, and maybe also because he loves OCA, I don't know. But anyway, so the Forensic Science Commission, their 3 staff will be coming over sometime this fall. Senate Bill 1326 was also a Judicial Council recommendation. This is the mental health recommendations from the Judicial Council. It's also a very significant piece of legislation. It deals with a number of different things. One, to improve screening and assessment of people who are arrested for mental illness and diverting them out of the jails to the degree possible. That's the reference to 1622. That is a provision under the Code of Criminal Procedure, which basically says that everyone has to, if someone is screened to show a mental health issue, that information has to be provided to the magistrate. That has not been being done very effectively. So basically, that will be done. And then if they're shown to have a mental health issue that's provided to the magistrate has to order them to have a full assessment. If they're found to have a mental health issue, they're required to be sent out to outpatient treatment unless it's a violent offense. So it tries to get those people who are low-level mental health offenders out of the system as quickly as possible. The reporting requirement is to OCA, and that is on the number of assessments that have been conducted under 1622. So that's a new reporting requirement that we'll be having to figure out how to implement. The other thing that's required is right now there's a requirement that courts submit when someone is potentially incompetent and they're evaluated to see whether or not they're competent to stand trial. Right now the law requires that those copies of those competency evaluations be sent to the to CUMI. I don't know what it stands for.
Texas Council on Mental Offenders.
Well, you're missing a few O's, but Texas Council on Offenders with Mental Illness. Yeah. So anyway, they're with TDCJ, and we talked to them during the session about what they were doing with those, and they told us they were sticking them in a box in the corner, and that was it. And so one of the big issues was we don't really know how much this happens in the state, and so as part of the data collection, the Judicial Council recommended those. Actually, the information on the number of competency evaluations, not the actual reports, but the number be reported to OCA. So we'll be getting the number of assessments for mental illness on the front end, and the number of competency evaluations on the back end. The other thing we're required to do is for the next year and a half at least, collect data on the specialty courts to determine the impact on specialty courts with regard to mental health conditions. So that's something we'll be having to collect data from all the specialty courts, which is a huge advance in kind of where we're at right now. There's not really a central place where data is collected on the specialty courts right now. And when we talked about specialty courts, I'm referring to like the drug court, DWI court, mental health court, veterans court, that type of thing. not our child support, child protection courts. And then lastly, we're required to release best practices to the judges on how to handle individuals with mental health issues. So we'll be putting out best practices, and I know we'll be working with TIDC on some of that because they've got some stuff on that, but then also looking at other studies in states and counties, how they're handling mental health issues to try to make sure that information is provided to the judges. So a very significant bill awaiting the governor's signature as well on that one. The other thing I should just say, it's not up here, but you all should just know, because I think this is a big deal from the perspective of just being a citizen of this state. You know, there's a lot of attention during the session and before session on mental health. One of the big bills that they also passed and not listed here is Senate Bill 292. And Senate Bill 292 provides about $60 million in funding allocated to every county in the state that's interested to implement what they're calling community collaboratives to try to improve mental health services in all the counties across the state. So the top 10 or 20 counties, I can't remember if it's 10 or 20, get a formula amount, and they're going to get about 40% of all that money, that $60 million. So I guess 24 million of that will go to the top 10 or 20 counties. The rest of the counties across the state can compete for that money to improve mental health. So it could be that, say, TIDC has a recommendation or we make a recommendation about a best practice, they can then go get that money to fund that. So it's a really big deal. You know, one of the big issues we looked at in the Mental Health Committee was, Judicial Council's Mental Health Committee, was the lack of resources, mental health resources all across the state. It's not going to get there, but it's definitely a step in the right direction. In those counties where they do this, there has to be some matching funds from the counties to be able to try to sort of double the money. So we'll see what happens with that. So that's an important advancement, I think, too. Lastly, Senate Bill 1911 requires OCA to post self-help resources on our website. So this is to try to help people who are, I guess I should say, it says just generally self-help resources, but lots of self-help resources. These are for litigants who are trying to access the court system to try to post. There's some specific requirements in the bill about things that we're supposed to post. But basically, it's trying to find a one-stop shop for people who are trying to look for how to access the justice system by themselves. So we'll be doing that. And then all the clerks across the state are required to post a link to this on their website as well. So that's to be that one will be coming as well. So any questions about any of these bills that directly affect OCA?
So only one of them's been signed, Senate Bill 42 so far?
42 and 1096 have been signed. I don't believe 3167 signed. That's it.
Okay.
So there's still several to go. Yes.
On 1911, the last one, how does other websites like texaslawhelp.org, those are pretty much that, isn't it?
They are and they're not. So there's a requirement that we put Texas Law Help, for instance, on our website. But they wanted a government entity to be, Texas Law Help is not a government entity, it's a nonprofit. Run by a nonprofit. So the goal here is to have one place, one-stop shop. But Texas Law Help is required, it's one of the things in the list of required to be on there. The other thing we do is we put, in many of the counties, maybe not almost all, but many of the counties have legal aid providers or even volunteer legal providers. So we're required to put those resources on there too. So collecting that's going to be an interesting challenge for us, but basically putting that all together on a place where people can come and search. I think about for instance, our map that we have on the resources, and I don't know if you all have been on our website, there's a map that you can click on the county that shows you, how to contact all the judges, the clerks, if they had e-filing or not. At the time when we did it, that was sort of an issue, whether they had public access to court record websites and things like that. This is something where we'll be probably adding to that as well. All right, any other questions on these? Tracy?
Quick question. As far as I can tell, we're getting 35 new FTEs, correct? 31 for the guardianship, 1 for the security,
And
court
3.
security, and then 3 transferring over.
I believe that sounds
That's right,
right.
that's right.
Sounds right. Okay. On the 3 that are transferring over from the forensic division, who are they going to report to, or are they going to be kind of a separate
They
entity?
still report to their executive director,
Mhm.
right?
We haven't
We
really
haven't
gotten to that
done
far
that.
yet.
Okay.
So they'll need to report somewhere internally to OCA, because they actually don't have an executive director. They have a chair of their commission. So my guess is they'll probably report to me to some degree, or at least the general counsel will probably report to me, and then she has 2 other employees. But we'll have to figure that out. I don't know. I'd love to shift it off to somebody. You want them, Tracy? Anybody volunteer?
Scott Griffin.
Yeah, Scott sounds good.
He
did show up, you know.
I'm
here.
here.
So anyway, that's a good question. Any other questions?
David, I have a question, and I was late, so I may have missed this. But the court security bill, does that apply to the associate judges?
It applies to every judge in the state is listed. The other thing I should mention is there are a number of provisions where they can get their information delisted from various public sources of data. Which I should say too, we need to talk about this internally, but there's also a provision where employees of judges can also get rid of it. So like out of the appraisal district records, the voter registration records, basically they can get all their information delisted. It doesn't
That was
apply
in
to
your
others.
cortex, if you all read it.
That's right. All right. Any other questions on these? Got a few more here to go over, and then. Okay. So a few other judicial council bills that don't directly apply to OCA, but clearly deal with the courts in some form or fashion. One is the Senate Bill 1913. I should also put House Bill 351. They're virtually the same. Few minor differences. But basically, this deals with court cost and fine collections. And options to increase compliance. This came out of the Judicial Council's work on trying to provide additional options for judges and defendants to satisfy their court costs and fines. So for instance, just to give you an example, the bills require the judge at sentencing to ask the defendant the question about whether or not he or she has the ability to pay whatever's been assessed in fines and costs. And if the answer is yes, of course, then things move on. If the answer is no, then the judge can go through a determination of determining whether they should be put on an installment plan, whether it should be satisfied through community service, or whether or not it should be waived in some either part or full, or some combination thereof. So it gives the judges additional options as well as defendants. In addition, it also expands the number of community service options. Right now, it's kind of narrow in the community service options that are allowed, so it provides additional options. Also requires before a warrant is issued for failure to appear, they have to provide a notice to the defendant that says if you don't come in the next 30 days, we're going to issue a warrant for your arrest. Same thing on capias pro fines where people don't pay their court costs, basically saying you've got to come in and get this situation resolved or else we're going to issue a warrant. And then the other one, another couple things in there. One is it requires any notices going out from the court to talk about the fact that if they can't afford to pay the court costs and fines, that they can choose to talk to the judge about alternatives to paying. So those are the types of things that are in that bill. So we're waiting on the governor's decision on that one. House Bill 34 is the Timothy Cole Exoneration Review Commission recommendations. A lot of the hard work of some of our staff, Terry and Alejandra and Wesley, went into the Exoneration Review Commission. A number of others provided support as well, but those were the three main staff. Basically, every recommendation from the Timothy Cole Exoneration Review Commission was put into place, modified maybe slightly, but you all might recall the presentation by those staff about that. But one of the main recommendations coming out of that is the required recording of custodial interrogations. So if you're in custody and being interrogated, there's now a requirement that it be recorded. And if it's not recorded and there's not good cause why it was not recorded, the admission or the statement is not admissible in court unless there's a video of it. So that's audio or video, I should say, not just video, but there has to be a recording of it. It also dealt with eyewitness ID issues as well as some of the forensic science type things. So it's a pretty comprehensive bill. They made a few tweaks along the way, like for instance, the audio video recording recommendation was all custodial interrogations on all felonies, and it got narrowed a little bit to not be all felonies, but it's the majority of the cases where there are custodial interrogations would be covered. So pretty exciting work there. The last one is Senate Bill 1329, and it's the omnibus courts bill. There's going to be several courts created out of this, but the main reason why I put it up here is because one of the Judicial Council recommendations was to have a central place to file all oaths of office, specifically with our associate judges and other appointees. There's always a question about where those are supposed to be filed. Now they will all be filed at the Secretary of State's office once this bill is signed into law and becomes effective. So that will answer that question that we always deal with. So what didn't make it, I'm sad to inform you that our pretrial bail reform bill Did not make it. There is a lobby that is very powerful who does not like that bill. You might guess who they are. Dog the Bounty Hunter and others like that. So they worked really hard against the bill, and so it did not pass. It made it through the Senate, passed with a pretty strong vote total in the Senate. It did not. It made it to the House and voted out of committee, but it did not get on a calendar where the House could consider it. So it was kind of late in the session when all that happened. So unfortunately, it did not pass, but we will not stop doing with this. You all might know that in new news, Harris County in mid-May, a federal judge ruled their system unconstitutional for misdemeanor defendants, required the county to take more extreme actions than what 1338 would have done with regard to releasing defendants who don't have the ability to pay on personal bond. And so that ruling was made. They appealed that to the Fifth Circuit Court of Appeals. The Fifth Circuit Court of Appeals immediately stayed that ruling, saying it couldn't go into effect. It was supposed to go into effect on May 15th. I think that was May 15th. The Fifth Circuit Court of Appeals issued a temporary stay, saying it didn't have to go into effect on May 15th. But then earlier this week, actually lifted the stay and said, no, it needs to go into effect after we looked at this a little longer. Harris County appealed that to the U.S. Supreme Court, and last night the U.S. Supreme Court, Justice Thomas, denied the stay, so it's now effective today. So people are being released as we speak. So I said I wonder if that industry that lobbied against this bill might like this bill better now than what they got there. We are told that Harris County is just the first Texas county and that there will be more. So we'll see. I'm still hopeful that sensible minds will come around and they'll decide that the work that we did on Senate Bill 1338 is a good bill, and that maybe we can see it come back. Another couple bills that didn't make it, judicial compensation bills. We had a bill for setting judicial compensation by formula. We had a bill regarding longevity pay for judges. You know, we all get longevity pay at 2 years, as you know. Once you have 2 years of service, you start getting some longevity pay. Judges don't get it until 16 years, and they only get a certain amount for the rest. It happens one time, and they get the same amount forever. It never changes. And it's not a tremendous amount of money for them either. So we were trying to make it match closer the employees, where it started at 2 years. That bill just didn't move, unfortunately. So still got more work to do on judicial compensation. The judicial retirement fix, you may or may not know that there's a provision in law that says if you are a judge and you retire, and then you decide to run again for office and you get elected, that when you come back into office, your retirement benefits as far as collecting your checks stop. You can't re-enter the retirement system and you get no credit for the time you're serving. It's pretty horrible. So Judge Richardson on the Court of Criminal Appeals is an example of a judge. There are another couple of other judges who are in the same situation. So Judge Richardson, for whatever length of time he chooses to serve as a judge on the Court of Criminal Appeals, is getting no retirement benefit whatsoever and cannot collect his retirement check while he's here. So when he retires, whenever that is, he'll go back to making what he was making, before he retired the first time. So it's a bad issue, and the reason why we can't get it fixed, this is the second session we've tried, is not because people don't like the issue, like the idea we had to fix it, which is to basically put them back like the rest of us would be. But in order to make any changes to the retirement system has to be fiscally sound, meaning they have to dump a bunch of money into the system to make it fiscally sound before they can make any changes. So that's our issue there. Simplifying court costs and fees, we actually had a judicial council recommendation to do this, but because of some of the issues we had in the middle of the session dealing with clerks and things like that, we chose not to do anything that might be seen as us taking some attack upon the way they did things. So that bill, we didn't even push that bill. There was never even a recommendation or request to file that bill. So of course it didn't make it. And then lastly, the jury will reconstitution. Minna and Judy and Margie did a lot of work on this with the Secretary of State's office, and it was simply just updating terminology and practices the way we do things now. And it made it through the Senate easily, got to House committee, and there was some confusion about what it did, and so the bill did not pass. We tried many ways to get it back in and bring it back to life, but we were not successful, so that bill did not pass either. Any questions on any of these?
Was there a judge term limit bill?
There was a constitutional amendment to to deal with the lengthening judicial terms, to make them, for instance, the appellate courts would go from 6 to 8 years, and the district court judges would go from 4 to 6. That provision got stripped out before the bill passed out of the House. There was also a provision to increase the amount of service required for district judges to become eligible for office from 4 to 6 years. That made it through the House, but did not make it through the Senate. So that bill did not pass either. So no changes to judicial qualifications or tenure.
So is OSA going to pursue anything during the special session?
So that's one thing I was going to say. Thank you for reminding me. So there is a special session you might have heard. I saw something this morning on Twitter where the staff response to a special session was someone throwing a chair across the room. So they will be back July 18th for 30 days. The governor has called that special session. You might be wondering what's so special about July 18th. Well, the veto period ends on June 18th, and they can override a veto for 30 days. And so July 18th is after they can override a veto. So that would be the reason why July 18th is here. Not because Austin's such a wonderful place to be in July and August. But basically, the governor has called them back for one reason right now, which is to fix a sunset bill provision. So as you may have read and heard, they have to, anybody who's under sunset means their agency will expire and not be allowed to continue if they are not reauthorized every 12 years generally. So the Texas Medical Board and a couple of other agencies, their bill did not pass, and they generally have a bill that's called the Sunset Saving Bill, which basically says, oh, if they didn't pass, well, we're going to extend them anyway for another 2 years, and that allows them to kind of come back next session and work on it. That bill was killed in the House through some gamesmanship, and then was killed in the Senate through who knows what you want to call it. Anyway, so that bill did not pass, and so technically the medical board and these other agencies will expire at the end of this fiscal year, meaning that starting in September there would be no regulatory body of doctors.
Nice.
Or licensing.
No money.
And Scott's just glad he no longer. Is it Margie or you who worked? Margie worked at the medical board. She's glad she got out when she did. But basically, so the first issue, the only call currently for the special session is to pass the sunset bill. The governor has said earlier this week that as soon as they pass that, he will add 19 other items to the agenda. You've probably seen them, but it's teacher pay raise, teacher retention, bathrooms, or privacy, the property tax reform, and there's a number of city annexation of land. There's another number of other items.
The anti-Austin bill.
I don't even understand that one. I need to read more about that one. But there is currently nothing on the special call that deals directly with the judiciary. There may be, just because it's not on the special call doesn't mean bills can't be filed. It just means that if someone were to call a point of order or whatever, that it wasn't, that it could stop it. So my guess is there will be bills filed affecting the judiciary. And there may be other things the governor adds between now and then. So we'll have to wait and see to see how that goes. But I mean, there's some things that we didn't get past that might be interesting.
Would they be revived?
It could be. I mean, if the governor puts it on the call, anything can happen. So bill filing begins 30 days before session. So June 18th, they'll start filing bills. So we'll start getting fiscal notes. And
What was the total fiscal note process this year?
I should have added that up. I think it was around 1,350.
So you could still have more.
Which is I think we and that's actually submitted, I believe. It's definitely a record. It's way up compared to what we. And I don't think Lisa's here, but we should all recognize Lisa for sure. Lisa Kinsler did a tremendous amount of work helping us with fiscal notes, and I know a number of you in this room were responsible for contributing to that, and I greatly appreciate all your work on that. That was definitely a labor, but we made it. And so
Compensation bill was.
yeah. Any other questions? I know we're to the end here. I'm glad you went faster than you thought.
I know, I knew that. Well,
Any other,
what to talk about.
I like to talk, right?
When does the crowding and the lack of parking start?
No.
I'm just kidding.
Oh,
The traffic and the.
July 18th would be that. If I'm not
Everybody show up.
crowding in our office. Just so you know, so for those of you that are interested, the directors are meeting next Friday all day long to talk about implementation of a lot of these bills. So we'll have a better. We've already sort of each individually sort of started coming up with plans on how to implement some of these, but we're going to work together. Some of you may get involved in that, as we go, but we'll have more, some of these questions about, when and all that will need to be decided on that day. But what we do know is we've got 31 staff to hire for the guardianship compliance project. We've got a security director to hire. So just know that that funding becomes available September 1st, but most likely those jobs will start to get posted over the summer. So if you have people who you think might be well qualified for those jobs, I hope you'll let them know about it. Obviously, we would want the most qualified people we can provide for each of the jobs.
If you would let me know, and I'll send you a link to CAPS,
Yeah.
and they can go ahead and set up their application, and then they'll be ready to start applying.
So I think in mid to end of July, you'll start to see some of those guardianship jobs posted. I don't know exactly yet when the security job will be posted. We'll be talking about that, but just know they're coming. And as Jennifer said, most of the guardianship staff, those 31 staff, most of them will be across the state. So if you've got people that you think are well qualified in various places across the state, they may be an appropriate one. I don't know that we're particularly looking for a specific spot in the state as much as we are looking for people that are well qualified, and then there's a lot of traveling involved and them going to various offices. So just keep that in mind as you think about people who you would like to be on our team. We want the best, just like we have. So whatever we can do to make that happen. Any other questions? Yeah, I'm going to ask. Any other questions about legislative session? All right. Well, thank you all. So let's see. Last thing we always do is there anyone who this is your first quarterly meeting that you just started? I see a few faces around the room that I don't recognize. So,
You have to stand up.
So introduce yourself. Where you work, what you do, how long you been with OCA. So we'll start with that.
I'm Lisa. I'm the administrative assistant for OCA 6th, and I've been here for about 3 months.
Welcome.
I'm Scott. I'm a policy analyst at TIDC. I started in December.
Excuse me, he's Scott Ford.
Scott number 4. Wow.
You're the new Amanda's.
I'm Susan. I'm a summer law clerk with TIDC, and I've been here like 2 weeks, 2.5 weeks.
I'm Rebecca Young, and I'm also a summer law clerk with the TIDC.
Anyone else? All right. Any other questions or comments before we get out of here? All right. Well, once again, from me to you, thank you for all the work you do. You make this place a great place to be and a very well-respected agency, and I'm just glad I can be a part of it. So thank you all, and if you have any questions, let us know. We'll send this out to you tomorrow, I guess, as part of the week. Thank you all. Bye-bye.